Hi, I'm attorney Bailey Means of Means and Means LLP. I'm going to give you some very brief but seemingly positive updates on SB 1437 from the appellate courts. So, if you've been following SB 1437, which is the felony murder resentencing and redefinition of felony murder law, you know that it's facing constitutional challenges all over the state, and no appellate court yet has come down on the constitutionality issue. So that's kind of what we're waiting on in the trial courts across the state. Trial courts have issued many differing opinions on the issue, and no one's really in accord of what's going on or the constitutionality as of now. So everyone's just waiting for the higher courts to decide this constitutionality issue. So in the past month or 6 weeks or so, we've gotten a few seemingly positive updates from the appellate courts. So one that I want to discuss real quick is the Ortega versus Superior Court case. That's out of the 6th District from Santa Clara County. Similar to Ortega is the Torres case, which is out of, I apologize, the Ortega case is actually out of the 1st District, Contra Costa County. Torres is out of the 6th District, which is Santa Clara County. So both of them are open cases, meaning that the defendants have not been convicted yet. They are currently facing murder charges. They're both in a little bit different postures, but very similar. So, like I said, they're both open cases. Both defendants brought a challenge to the trial court saying, I can no longer be prosecuted for murder because the felony murder statute has changed, and you are attempting to prosecute me under the old statute. So they're essentially saying that they are barred from being prosecuted because of the changes to the law, and their conduct that is alleged against them is no longer constituting felony murder. So both trial courts denied their challenges, meaning they allowed the prosecutions to go forward. So both Contra Costa and Santa Clara County allowed these prosecutions to go forward. Both defendants then filed writs with their respective appellate courts, and both appellate courts granted the writ and issued orders to show cause as to why these defendants should not be granted 1437 relief. Those are a lot of legalese, big words, saying essentially the appellate court told the trial court to stop the trials, stop the prosecution, and show cause as to why these defendants should not be granted the relief afforded to them under 1437. So the appellate courts are essentially saying, we think that these people might be entitled to relief, stop their prosecution, and show why they're not entitled to the relief. So those are positive updates. We're expecting some updates on those cases by the end of this month, although we won't have a decision on them for probably a couple months, maybe around July. But they're going faster than normal cases because they were writs and not appeals. So those are the two writ cases. Additionally, we have some updates as to the issue of whether 1437 is applicable to attempted murder cases. So going in, there was kind of a discussion or a debate as to whether 1437 is applicable to attempted murder cases because the intent requirement is a little bit different for attempted murder. Without getting into the details, let's just say it's a little bit different, and it affects whether 1437 is applicable to attempted murder. But in certain circumstances, specifically attempted murder under a natural and probable consequences theory, there have been two cases in which the courts have indicated that it may apply. So the first case is the Mateo case, which most people already know about because it was in the California Supreme Court and it was remanded back down to the 2nd District. The 2nd District encompasses both Ventura and Los Angeles County. That is an attempted murder case. So the Supreme Court remanded it back down to the 2nd District in order for them to uh, discuss and figure out what effect, if any, 1437 has on that appeal. So it was already an attempted murder case that had gone up on appeal before 1437 went into effect. And now they're doing supplemental briefing on what effect, if any, 1437 has on this attempted murder case. So People versus Mateo is one case in which the appellate courts are looking at whether 1437 applies to attempted murder. Another one that just went through the trial court, this occurred in Contra Costa County. A trial court in Contra Costa County found that attempted murder is eligible for relief under 1437 because there is an equal protection issue if you afford relief under a natural and probable consequences theory to felony murder or just murder under natural and probable consequences, and not to attempted murder under natural and probable consequences. The short of the issue is essentially if the person died, the defendant may be eligible for relief under 1437, whereas the person did not die, the defendant would not be eligible for relief under 1437. So you can kind of see just common sense that that would present an equal protection issue. So that one undoubtedly will go up on appeal. We expect the DAs to appeal that decision. But right now we're waiting on some sort of appellate decision on the constitutionality issue, hopefully from one of the writ cases since they're moving faster. We're looking for hopefully by July, but we'll keep you guys updated with anything that we hear. As always, contact us if you have any questions about SB 1437 or you think your loved one might be eligible.